All right. My name is Mr. Max Chaudhary of Chaudhary Law Office. This is the periodic webinar that I hold for people who reach out to us with general queries. The purpose of this webinar is to try to give some general guidance for people who may be not fully clear on the options available to them, perhaps after they've maybe looked on social media, maybe looked at online fora, maybe heard rumors. These are the tendencies we see, especially in the rapidly changing Canadian immigration environment. People will feel free to obviously come and go and pose their question. What we want to emphasize is that the portions of this webinar will be posted on social media. So for the sake of confidentiality, please keep your question anonymous, but obviously keep the substance of it sufficiently detailed enough so I can try to give a meaningful response to that. And if there are more than one set of people at a time, because people tend to come and go, then it may make sense to pose your question by typing it in the chat. And that way I can maybe get a bit of context. And in the case of a question where there is a bit more detail needed, I will review the question and then ask for more detail. I don't see any questions right now in the chat, so I'm going to go to the questions that were previously sent to me, unless I see a new question, in which case let me go to the new question. So somebody says right now, I'm in Toronto right now. I came in 2024. And what are my options if I want to apply for refugee or asylum? And then what are the chances to be approved for a PRA? So in this extremely changed landscape, the main things to keep in mind are the key dates for somebody in Canada. So there are certain, I would call them, let's call the first one, the first entry trigger. So that would be like June 24th, 2020. So under the new multiple entry provision, there is a 1-year deadline to file a refugee claim. It begins at the exact date of the claimant's first entry into Canada after June 2020. So, in other words, if the person entered Canada briefly as a visitor after, and then after this date left, and then returned later, years later, to claim asylum, then they're immediately barred because they cannot take advantage of this. The 1-year clock's 1-year sort of expiration started ticking during their initial visit. So claims from individuals who arrived before this date of June 24th, 2020, and never left, or who have no entries after this date, they should not be subject to this new restriction. There's another date which is of relevance as well, which is June 3rd, 2025. So in this instance, the new ineligibility procedures would be taking effect in this case. Essentially, they are being applied retroactively to any refugee claim submitted on or after June the 3rd, 2025. And this is when the legislation, which was originally Bill C2, was introduced into Parliament. So this means that even if a refugee claimant's file was already processed and referred to the Refugee Protection Division of the Immigration and Refugee Board, or even if they had a hearing scheduled, it will be retroactively pulled from the Immigration and Refugee Board stream and found ineligible if it was filed on or after June the 3rd, 2025. But claims made before this date are exempt from the new ineligibility rules. And the other more sort of recent date is the 26th of March, 2026. And this is the date that Bill C12 officially received royal assent, immediately triggering the enforcement of the new ineligibility provisions. So in this instance, if you fall under one of these situations, for example, you did visit Canada before 2020, or you made the refugee claim after June 2026, then you probably cannot make a refugee claim. I mean, this is going to be challenged at the federal court, but to take advantage of that challenge, you would have to say you're affected or have standing by, for example, already having a refugee claim filed, and then be a part of this forthcoming litigation, which is going to be no doubt a group litigation for this. So there are other impediments to making a refugee claim. So beyond missing the strict timeline cutoffs I've just mentioned, there are several other significant statutory and procedural impediments preventing claimants from accessing the Refugee Protection Division. For example, there is the 14-day irregular entry bar. So claimants who enter Canada between the official ports of entry along the Canada-US land border are completely ineligible for an IRB hearing if they waited more than 14 days to file their claim from entering Canada. Other aspects which are, I think, codified, which are relevant, that there are strict physical presence requirements. The new legislation clarifies that the RPD can conduct admissibility hearings, hold refugee claim hearings, or render decisions on the merits of a claim if the claimant is inside of Canada, physically speaking. The corollary of this has been codified, which is there's an automatic abandonment rule. A claim is automatically declared abandoned if the claimant voluntarily returns to the country they are seeking protection from before the IRB has made a decision. Also, an officer must declare a claim abandoned if it cannot continue because the claimant has left Canada. So there is a kind of transitional situation going on at the moment, which is that there is a suspension of paper-based processing. So to enforce this new physical presence requirement, the IRB has temporarily paused its file review or paper-based processing for the less complex refugee claims that have been filed. By contrast, previously, certain well-documented or vulnerable claims could be accepted without a formal hearing. However, now these claims are being redirected to short, expedited oral hearings to confirm the individual's physical presence in the country. So that's sort of the general lay of the land for these kinds of refugee situations, which could affect you depending on whether those dates are leaving you sort of left behind. For example, being in Canada before 2020 or filing the claim after June 2026. So with that, in that situation, I hope that provides some guidance for the people who are posing this type of question for this. If you're still in doubt, you can always book a consultation with us, and we can go into the chronology of your entry into and out of Canada, factor in whether you're a citizen of a certain country like the United States or more traditional refugee-seeking countries, such as in Asia. I just want to go to the other questions which have been posed beforehand, and that relates to, in this case, a refused visitor visa. This, in terms of the background the person gave, they had a previous visitor visa refusal in the past, but despite that, were able to visit the European Union, the United Kingdom, had visitor visas for those countries, obviously, right? Then there's an assertion that the person is settled in the Gulf, Persian Gulf, I presume, with property and a functioning business, have multiple passports, Turkish and Pakistani, and have no intention based on the fact that they're having a very busy business in the Gulf. So And they've elaborated that the children are in private school in the Gulf. Actually, sorry, no, they said the children are in private school in the United Kingdom, living in a kind of posh area near Wimbledon. And he wants to visit Canada. So the issue here is that since 2025, there's been a big push to remove people with temporary residence from Canada as soon as legally possible. So, for example, as soon as their visa expires. I think the consequence of that is that there has been some more difficult issues related to acquiring a visitor visa, in spite of the fact that somebody may present themselves as having all of the hallmarks of a genuine visitor, which is namely, if you're working age and you have, for example, a good job or a good business, which on the face of it compels you to only spend a certain amount of time visiting Canada, then on the face of it, there's no doubt that you're probably a safe risk and you would have to return to Canada. In a situation like this, where the individual has had a refusal in the past, that negative record has been compounded with the use of artificial intelligence, which is assisting officers in making visitor visa applications. So the tendency appears to be that the artificial intelligence will scrape what it deems to be the substance of the visitor visa application. And rather than looking at it in a holistic way, will take what it deems salient. And then in some instances, the rumor is that the officer is only looking at the sort of AI generated summary of the visitor visa application, and consequently making a decision without the entire nuance, without the entire factual matrix supporting the visitor visa application. We've seen this, for example, when there are intervening parties like VFS who are submitting the visitor visa application. And historically, there have been some instances where they're saying, yeah, you don't need to submit every page of your passport, which in fact shows all of the positive travel history traveling to the visitor visa exempt countries, at least those for people from developed countries, and showing a track record of returning. And this leads to, again, the lack of full nuance and the lack of full context by the officer when disposing of these visitor visa applications, leading to refusal. So then the option is, well, the remedies for this individual. In theory, you could reapply for a visitor visa application. The issue sometimes is that a subsequent application is refused within a few days just because the artificial intelligence has seemed to have accelerated the negative refusals of visitor visas in the case of a subsequent or second application. In some instances, traditionally, when the person is sufficiently motivated, and then we see the second refusal, and if the case looks like the person does have a positive profile consistent with a genuine visitor, then we recommend judicial review at the federal court, or in some cases, a combination of reconsideration of the negative decision along with federal court. Doing both at the same time is allowing the person to preserve their rights at federal court because there's a due date. And then if the reconsideration is not successful, then the idea would be that the federal court case could continue because it was filed within the limitation period from the date of first receiving the visitor visa refusal. So I hope that goes to that individual. I'll just see if there's a follow-up question in the chat. So in cases, in terms of the question that is being posed, is what our service is in relation to the refugee type of matter posed earlier. So we do process refugee cases, including full representation at the Immigration and Refugee Board. And the other follow-up is, do you help in applying for PR for the spouse who's completing her PhD from the USA? And this individual has an MBA. from the United States and a bachelor's from Pakistan. So, and then the question is, what would the chances be for permanent residency? So, there's been an announcement, I believe, 10 days ago, or uh, from the immigration department saying that they want to revamp the express entry system, streamline it in certain ways. So, for example, right now the express entry system is characterized by subcategories such as federal skilled trades, Canada experience class, and federal skilled worker. And then there's some idiosyncratic criteria for each one. So one of their proposals is to just streamline it and make it more more aligned with the express entry criteria, which is really the superseding overarching criteria anyways, and then have some consistency related to what the language requirement would be. The rumor is that they're considering lowering the CLB to level 6, whereas some categories at CLB 7, and then tying the types of occupations they want to jobs in Canada where there is a proven track record of economic establishment based on the median wage for those jobs, amongst other reasons. So that's kind of tweaking the existing express entry system. By contrast, as of 2025 until 2026, there's this phenomenon of targeted draws, which are prioritized based on short to medium term labor needs, such as related to healthcare or teaching. There's some idiosyncratic ones like insurance adjuster, I think. I'm not sure why. And those targeted draws means there are lower points required. And then if there are lower points required, then the chances of success are higher. If we look at the current system in the aggregate, then you tend to lose points significantly after age 35. And you lose a lot of points if you don't have fluency in English. On the other hand, there's still a priority for French language speakers, although that may change in the proposed system that they are canvassing these days. The master's helps, but the persistency of the targeted draws from 2025 even up to now means that the chances of success relate to whether you have a occupation which would be subject to the targeted draw. And you could look at the history of these targeted draws and compare your work experience to the occupations that were ultimately selected for permanent residency in the past 18 months or so. And that could give you a clue for this. General guidelines for this are to make sure that you are confident about what you are putting in your express entry profile, which is the precondition for the invitation to apply, is actually consistent with your skills and education. We see too many cases where people have put in an express entry profile, and what has happened is they may not have characterized their work experience accurately. We've seen this particularly with individuals who want to get the extra points for foreign work experience, and they don't have sufficient evidence to prove that they have the 1 or 2 years of foreign work experience. The evidence that is needed is generally credible third-party evidence, such as a reference letter from the foreign employer, proof that you were paid a salary and did perform the duties that you were asserting are relevant and are placed in the express entry profile. So the negative scenario is that by the time you get the invitation to apply, then you try to get the work experience evidence about the foreign work experience, and perhaps you can get some of the evidence, but not all of it. So, for example, you may get the evidence of the job reference letter, but you may not have the evidence of being paid during the whole tenure of employment, or vice versa. You may have proof of salary, but the job reference letter may not be sufficiently detailed. And then the points that you were asserting under the express entry profile are removed, and then your electronic application for permanent residency in the subsequently filed application after the invitation to apply was received gets denied. And this is potentially prejudicial because you don't know when the next invitation to apply relating to your occupation will take place because they are quite sporadic. So this is a good instance where you really want to know what the criteria is under express entry and interpret the requirements for what goes into that express entry profile properly to avoid disappointment. And you could consider retaining a law firm. We have 3 lawyers here who engage in that type of uh, application. So, with that in mind, I will take a look at the other questions in the chat, and then because I know people will come and go for this. So, yeah, the other question relates to common law and express entry. So, common law is kind of like marriage, except you don't have the marriage certificate. The issue the person has expressed is that they want to know, is there uh, any advantage to having a common law partner? So in some instances, it really depends on the credentials of the common law partner in relation to yours and the express entry category you're filing under. So if the common law partner does have high amount of English, for example, and masters, and maybe they have what we call adaptability points, namely they've worked in Canada, then it could be advantageous. And the other scenario is whether or not to declare that the common law partner intends to immigrate with you at the time of filing the permanent residency. And this has happened in the past where adding the common law partner didn't lead to as many points. They did not have, let's say, adaptability points or high English or high education or high French. So then, from a tactical point of view, some people historically said they're not putting their common law partner as a dependent on this application and intending to file their sponsorship later. This has led to some what are called procedural fairness letters, where they're accusing you misrepresented. And as a consequence, this led to some refusals when the immigration department was not satisfied that the person, in fact, did not want to sponsor or did not want to immigrate at the same time with their common law partner. So you have to tread very, very carefully about this. The context further for this is that with common law partners, it's sort of immigration 101 that if you have lived for 1 year in a marriage-like relationship, then before you land as a permanent residency, even if the person is not intending to immigrate with you now, but intends to immigrate with you later, it's imperative that you declare the existence of the common law relationship. If you have been living in Canada or been living together anywhere with a common law partner for 1 year before you land as a permanent resident, the consequence is that if you do not, then they could take away your permanent residency status after you acquired it on the basis of a material misrepresentation. The material misrepresentation being that you failed to declare that you had a common law partner. And it is material because if you're immigrating under the Canada Experience class or any of the express entry categories, they want to be satisfied that the common law partner or even spouse was examined for criminality, examined for medical admissibility, because those things could have barred your application from even being successful. So that's sort of the basic tenet to keep in mind about in the sort of interplay between common law and these express entry categories. you don't want to end up in a situation where your status, you've landed, and then your status might be taken away and you have to appeal after, for example, a proceeding at the Immigration Division of the Immigration and Refugee Board, and then a subsequent formal appeal at the Immigration Appeal Division of the Immigration and Refugee Board, where you have to plead humanitarian and compassionate circumstances for this. And then another question here. Oh, yes, just for anybody who's joining, please feel free to pose the question in the chat. In the meantime, I'll look at the questions that people posed to me earlier. Again, a reminder that portions of this will be on social media. So if you please try to retain your anonymity by simply posing the question with enough detail and not to sort of dox yourself or reveal who you are in this, because as I said, this will be on social media. In terms of another question we have, it's related to business immigration from the United States. So this person says they're in the United States, Mexican citizen, have an asylum claim pending. Then they have the DACA status in the United States, so they have to renew that every 3 years. They've built a life for themselves, it looks like. They have a bachelor's degree in business administration with accounting. No relatives in Canada. They have 2 businesses in Canada and have some money to invest in Canada. So the initial question is, can they try to acquire permanent residency and status? So if the person is, I think they said 42 years old, it's very, very difficult to immigrate under the express entry categories. Unless perhaps, as they stand now, you're fluent in French and English and have relevant experience, then the chance could be higher based on the targeted French language draws for this. But in the absence of that scenario, then what this individual may be looking at is an entrepreneur application. The entrepreneur applications are primarily assessed by the provinces these days. So the idea is that with a certain kind of net worth and a certain amount of money to invest or purchase a business, you express that through credible bank statements and through a viable business plan in the case of intending to establish a business. Or if you're lucky enough, you can make an exploratory visit, see a business you like and purchase it, and then at least work on a work permit. If the work permit is at a senior managerial level. There used to be a regime where you could get 200 extra points under express entry and then probably make the points that way. That 200 points has been paused. So in this scenario, the individual would have to go fully into one of the provincial streams and go through the assessment through one of the provinces. So for example, I believe in British Columbia, if you're making an investment in a smaller city, then you can invest $100,000 and have a net worth of around 500,000 or so Canadian. And then if the province likes the plan of establishing the business, then they give you a certificate to apply for a work permit, and then they monitor the business for about 18 months or so. And thereafter, the province of British Columbia would issue another certificate to allow you to apply for permanent residency if they're satisfied that the business you've proposed was borne out by, for example, the business plan that you expressed to the British Columbia Immigration Entrepreneur Authorities at the outset of seeking to enter Canada first as a worker on the business. That's sort of the broad way of looking at the alternative pathway in the absence of express entry, but with some viable business experience, such as business experience showing you've made a profit for 2 years in the previous 5 years. I mean, that's sort of the general requirement for these entrepreneur programs. If I look at the chat, there's a question here, which is, what if I have a citizenship common law partner and applied for a refugee, which is refused? Will he be able to sponsor me if he's married? So I think the question is, if the person has an asylum claim but is common law with, I think, a Canadian citizen. And then um, if that common law partner can sponsor the uh, refugee claimant while the common law partner is technically married and has kids. So the kind of lens you have to look at for this is there credible evidence of being common law? So that's a very general question. But if we try to scratch the surface of that a bit deeper, then by definition, common law means you're in a marriage-like relationship with this individual who may be, let's say, technically married on paper with children, but not divorced. If there's a genuine reason why the person could not get divorced, and at the same time, if the hallmarks for a genuine common law relationship are present, namely that you're living for 1 year in a marriage-like relationship, you're doing household chores, maybe if he has health insurance, you're listed as the common law dependent. By definition, as the beneficiary of those health insurance benefits that he may have from an employer. Let's say you have driver's licenses, the same address. You have car insurance for each other if there's a common car between you. If you have all of those things, then in some instances, he could still be a sponsor despite being married. I mean, there's some nuance to that. So I want to say in some instances, because you want to get the full picture about whether or not this meets I think the traditional criteria is the Supreme Court of Canada of MVH, M as in Mary versus V as in Victor, which laid out the groundwork and the criteria for common law relationships. So if I look at any other question here, the older question I see here is sponsoring a spouse while outside of Canada. Okay, so this looks like a technical question. So this is a Canadian citizen who is residing in the United States on a J1 visa while completing a 3-year internal medicine residency program, expected to finish in a few years. The spouse to be sponsored is a Pakistani citizen who's in Ontario on a visitor visa. She tried to enter the United States on a J2 visa and can't join the Canadian citizen studying medicine in the United States. So they're thinking about filing an outside of Canada spousal permanent resident application and are seeking advice about how to make that work because the sponsor is stuck for a few years completing medicine studies in the United States. So the issue here is that when you file a spousal sponsorship outside of Canada, you have to be a Canadian citizen, which this person is. And similarly, you have to show an intent to return to Canada when the applicant, in this case, the Pakistani wife's permanent resident visa is ready to be issued. That could be very difficult because in the general scheme of things, the sort of gold standard is evidence that the sponsor has a job in Canada, because as people know or should know, that a sponsorship means that there's a financial obligation for 3 years to take care of your spouse to avoid social benefits. So that means in order to prove that, you have to show that you have a job in Canada. So the best case scenario is that the timing of this sponsorship application would coincide with the sponsor's completion of his medical studies in Canada. And then the sponsor in particular, would have a job related to his field in Canada. And proof of that would be issued or would be available to be sent before the spousal sponsorship for his Pakistani spouse is disposed of. And then the officer would be very pleased to issue the visa because they'd see that there is evidence that the sponsor does intend to cease whatever he's doing in the United States and take up work in Canada. There may be middle positions where there's evidence that does not have to be as strong as evidence of working in Canada, but that's sort of the gold standard for this. Let's see, another question in the previous emails relates to a part of a family landing after the permanent residency for the entire family is approved. So in cases like this, then the person indicated they filed for permanent residency a couple of years ago, and then looks like the principal applicant landed, which is the norm, and they have both sons in Canada studying on study permits. And turns out the principal applicant and his spouse landed, and one of the children landed, but the two are still studying. So the issue is compounded because the passport for the sons who are studying expires in, it looks like, November 2026, and now we're in April 2026. So this could be a situation where the two sons who are studying, they're still paying international student fees, so they're not getting the benefit of that because they're not officially landed, and it says the passports are going to expire at a certain time. This could lead to a significant delay, in fact, a kind of sort of merry-go-round where you need to land, but in order to land, you need a valid passport. So if the immigration department is not going to issue that PR landing portal notice where you land by doing the virtual process, then the danger is that the two sons' passports will expire, and then this will further delay their ability to land as permanent residency pending the reissuance of their passports. This could lead to the expiration of medicals, because medicals may also have to be done, and the need for doing police checks. So this could really, really delay the landing for a long, long time while the basic requirements such as medicals and police checks expire. So the consequence is that you're really at the mercy of the immigration department. We see in our office people who've been approved in principle for 6 months, and now we have to do periodic calls. We do these bulk calls with the immigration department where we have 3 sets of clients. We call the call center. We manage to get through. We give the clients ID. We prove that we are the lawyers on file. And then we go through the process. And then the officer on the phone puts us on hold. And then they say, you just have to wait. No explanation, no nothing. So sometimes we try to do the access to information request to find out what's going on. We find out that sometimes there's no explanation. Other times there's some very arcane issue, like although they did not work for the government, they went to a school that's affiliated with the government, which is almost like a quasi-association with the government. And in the situation where the government is connected to some troublesome activity related to human rights violations or international spying, then this sometimes causes delays. So these are the issues that come up from time to time with delayed applications. So I'm just going to rotate to any question in the chat. So this relates to, I think, an earlier question, which is the person has a brother who's in Canada who has PR status, and would he be able to assist in getting assistance for the PR? So, I mean, right now, the short answer, simplistically, is yes, because you do get extra points if there is a brother or sister in Canada under the express entry point system for the comprehensive ranking scores. I mean, again, that may change because of the recent proposals. But the short answer is yes, as long as proving the brother is actually residing in Canada for this. But again, keep in mind that there may be some changes to the regulations, and that means the benefit of having the brother in Canada, namely the extra points, may not exist if they do change the regulations. I mean, changing the regulations could take some time. They're at the consultancy stage with stakeholders right now, so we're sort of waiting and seeing. So the other question is, can the C12 rule, which relates to the changing of who qualifies to make a refugee claim, can that be changed? So the short answer is yes, but it would have to be changed through litigation. There is going to be a litigation about this, but you'd have to have what's called standing in that litigation. So that would mean you'd have to say, I was affected because, for example, I filed a refugee claim and then they issued me a procedural fairness letter saying that we don't think you qualify for this. And then you make written representations to preserve your right to be a part of that litigation. We've done that process, presumably because the client who we've done that for is going to join that litigation. Keep in mind that you can't sort of sit on the sidelines. You have to be directly affected right now by this and take steps to be a part of that litigation. So if that litigation is successful, and fingers crossed, then only people who were in that litigation would get the benefit of the successful court case outcome. So that's something to keep in mind. If you think there is a fear of being returning to your home country based on your identity, for example. So with that in mind, I'll switch between questions in the chat and people who posed questions before. So what are the options for a permanent resident who may be deported because of a crime? So this is kind of a standard thing which we see from time to time. A permanent resident, they commit a crime. Depending on the crime, what happens is sometimes the Canada Border Service Agency discovers one offense, let's say a DUI, or maybe an assault. And I mean, they're crimes, so they're by their nature serious. I don't know why, but in some instances, they'll give you a chance simply to explain. And then if you write a good explanation saying, this was just not me, this was not in my character, I have a stable life, I have close family here, sometimes they will agree and not initiate proceedings that commence removal. On the other hand, they have discretion to issue what's called a Section 44 report, and that would basically allege that you are a permanent resident who is inadmissible under Section 36 of the Immigration Refugee Protection Act because you're not a Canadian citizen and you were convicted of a crime. In that instance, then there is recourse to the Immigration Division of the Immigration Refugee Board, where they would confirm the conviction. The next step in that scenario would be that in some instances, you could appeal this to the Immigration Appeal Division of the Immigration and Refugee Board. Not everybody gets a right of appeal. This issue is that if there was a term of imprisonment for your Canadian conviction, if that was 6 months or more, then you would not get that full appeal at the IAD, the Immigration Appeal Division, which means you would be stuck with doing what we call a generic H&C, a generic humanitarian compassionate application. And those are subject to extremely long processing times, could be 1 year, could be 10 years. You could be in danger of being deported while that H&C application is in process. So by contrast, if your imprisonment was less than 6 months, you'd have the full IAD right, which is like a hearing. Your lawyer would pose questions to you as examination chief. You'd be cross-examined by the opposing lawyer. You could have a witness like a spouse or a other close relative in Canada, showing your good character, showing your stability in terms of employment. If there's children in Canada, that would be affected by your removal. If they're under the age of 18, then the best interest of a child can be aggressively canvassed and written representations or more normally oral submissions can be made on your behalf in a litigious court-like environment. And you can get the benefit of a pause of the stay, typically for 2 to 5 years. And then if you're on good behavior and if you meet that good behavior, those terms and conditions are complied with for the 2 to 5 years after the IAD issues you a stay, then it could be lifted and then you could regain your track to get Canadian citizenship, which means getting on that road of residing in Canada for 3 years out of 5, etc., filing tax returns, this sort of thing. So I'm just going to look if there's a question in the chat. So for this relates to, can a visitor visa be converted to a work permit if you get a job in Winnipeg, Manitoba? Or is there no more LMIA? So, okay, there's a couple of background sort of state of the law things that have to be given in this situation. So it's generally very difficult to convert a visitor visa, namely somebody who has visitor status in Canada, into a work permit, unless, for example, they get married and then they file for the spousal open work permit. They can convert that visitor status to a work permit. Or if they're a student, and they can convert, if they qualify, their study permit into a post-graduation work permit. Aside from that, it's very difficult to convert it while you're here. So the order of operation, or the venue, rather, would be you're inside of Canada, and then you apply for the work permit at a visa office outside of Canada. The related question here is that, is there no more LMIA? So LMIAs, labor market impact assessments, they're highly restricted for lower skill jobs these days. They're fast-tracked for high skill jobs. So the idea is the positive LMIA would be issued, and then you'd submit that with your work permit application, which would be disposed of by a Canadian visa office outside of Canada. So that would be the way to kind of change your status to worker. In terms of the background to the same question, the person asking the question indicates that they came into Canada in 2024 while they were studying in the USA. So they came to visit from the USA. And then they went back to their country and lived there for a year and expressed an interest to apply for asylum. But because of C12, now they discovered that their case would now go to the pre-removal risk assessment venue, which is sort of like a non-arm's length officer as opposed to an arm's length tribunal of the Immigration Refugee Board, namely, leading to the low chance of success, which is generally true. So in a situation like this, they're saying, well, what can be done? If they go back, I think the only venue possible here is that if you've made the effort to at least try to initiate the claim at the IRB, done the admissibility steps and then got denied, then that might mean you could apply to be part of the litigation. But you still have to remain in Canada. So how do you remain in Canada? You have to be under an unenforceable removal order. But how do you know if you're under an unenforceable removal order? Well, one sort of hallmark is that, generally speaking, if you're eligible for a PRA, especially if you've not done one before, then you can stay while the PRA is in process. So you would have to, if at all possible, initiate the steps for the IRB claim, get denied, take that denial, become part of the court case group of litigants, and at the same time, while you're in Canada, try to stay in Canada by availing yourself of the inevitable pre-removal risk assessment that would be given to you. With any luck, there will be a flood or a deluge of pre-removal risk assessments. So that might mean that you'd have an impediment to removal that may take a long time for you to be removed because the flood of pre-removal risk assessments would be so great. In the best case scenario, if you end up being a part of that C12 litigation, if the court case is successful, then you would get the benefit of that, and then the case would have to be presumably reassessed to determine, in light of the Bill C12's effects being deemed unconstitutional, the IRB would have to revisit your ability to make the refugee claim. So that's sort of a rough sketch of what a best case scenario could be in this case of somebody who was affected by the adverse effects of the Bill C12, which came into effect March 26th, 2026. So I'm just going to go to, because there's still some time, I'm going to pose or go to the questions posed by email. So this person applied for the Ontario PNP application as, it looks like, a personal support worker, which is great because we need PSWs. However, they received an intent to refuse their application by the provincial authorities in Ontario. So in a case like this, they indicated that there was some concern that they did not have the required experience in Ontario. So for that particular category, I'm assuming it's the foreign worker stream, they need 2 years of paid full-time experience within the 5 years preceding the application. And that 5-year window is calculated backward from the time your application submission date is done, not the approval date. And work experience outside the 5-year window is disregarded. So to tackle this, hopefully your work experience was 2 years within the application submission date, not when it was accepted. Similarly, make sure the work experience that you're approving does align with the same NOC code. I'm going by memory, but the NOC code for this might be 33102. So your foreign work experience has to substantively meet that requirement. Otherwise, the PR application could be refused. I know in some cases, part-time work can count if, for example, it was more than 30 hours a week in more than one position for the 2 years. Or maybe, in some instances, 15 hours a week in one position for 4 years, but it has to be within the 5-year window. Keep that in mind, right? So if you're short the 2 years, then there's a strong chance you may not have a defense in response to that kind of procedural fairness letter. Procedural fairness letters, in general, are mandatory to be issued by the Canadian Immigration Office. If there's an instance where there's a concern that arose after you submitted your application, and it's a concern that you could not reasonably be aware of because, let's say, in 99% of cases, you comply with the document list for submitting the application, which has the whole host and the whole slew of documents. In that instance, for example, an officer may see there's a document that may not be credible. Maybe they called the employer in the job reference scenario. The employer says, I do not know who this person is. So then the immigration department would have to issue you a PFL, a procedural fairness letter, to give you maybe 7 to 30 days to respond. And hopefully there's an explanation about this. That could be, hopefully, that maybe, somebody was new at this place of employment, so they did not have the records handy, things of that nature. But that's sort of your one lifeline for preserving an application that might be in jeopardy of refusal through responding cogently to the procedural fairness letter, hopefully with some case law, if you're in the case of hiring counsel, like lawyers, such as here at our office, Chaudhary Law Office. Follow-up question to the work permit. I think we have a few minutes left here. So how long would a work permit take if this person falls into the 1-year rule? So for this, in the case of a work permit, there's different types of work permits. If it relates to the a person who is eligible for, let's say, a PRA, but they're not eligible for the full RPD, then the there's a wide variation, at least in our office, of work permit processing times for associated with refugees and claimants and quasi-refugee claimants. So in some instances, we see like 2 weeks from the date of the refugee interview. In the case of a PRA claimant, we've seen wrongful refusals for people who are under an unenforceable removal order. Because if you have a PRA, you cannot be deported. So that was the basis for our work permit applications for those individuals. They had a pending PRA. We've seen them get refused. We've had to file again and got approved. In theory, you could go to federal court, but it's just a huge production. You'd win, but there's seems to be some concern that there are some wrongful refusals if you're ending up in the PRA stream with the unenforceable removal order, just to make it a little bit more difficult for you to survive in Canada. But I'm speaking sort of in a bit more conspiratorial terms. I don't know. Maybe I'm speculating a little bit there, right? Another follow-up, since we have a couple of questions in the chat, is this person has done a PhD in education from the United States. And what would be the best way for that person to settle in Canada? So the person is contemplating applying directly for permanent residency or get a postdoctoral position and work through that. So a postdoctoral position, if that is under the auspices of, for example, a job offer, then you have to simply get the work permit. As you may know, if you've looked at the history of express entry draws in the past year, there have been some related to teaching. So teaching, if you end up with a job in teaching or have experience in the past teaching, you might have a competitive score under the current express entry regime if you're under, let's say, 35. In terms of coming with family on a work permit, they could come. It's not unusual. The concern you'd have to have is that based on your interactions with any immigration authority in any country in the world, would the Canadian officer be satisfied that if you're on the work permit and if your work permit expires and if there's no pathway for PR, permanent residency, would you leave Canada? So that's where, if, for example, you had a troubling history with any immigration authority in any country, that might jeopardize the chance of success for getting the work permit from the outset. So, but if that was not a concern, then the spouse could come as a spousal open work permit holder if you're going to be, let's say, studying for 16 months, or if you're having a job in a sufficient NOC tier level, I believe 0, 1, 2, or 3. There's the ones you have to be working in for your spouse to come as a spousal open work permit holder. So with that in mind, I think I'm at time. So I want to thank anybody who joined, and hopefully I answered their questions. And the website, if you want to consult with one of the three lawyers here, is www.chaudharylaw.com. We're a Canadian immigration lawyer, a set of lawyers based in Toronto, Ontario. And the email, just for the sake of completeness, is that to sort of deal with the intake or the website in general. There's also information on the website as well, which you want to maybe avail, because there's lots and lots of details about things like humanitarian compassionate applications, admissibility issues, some asylum things as well. And with that, I want to allow you to enjoy the rest of your day. Thank you.